Good morning, everybody. Welcome to our session today in conjunction with Hayes. But today we're focusing on the return to the workplace following lockdown. We're delighted that so many of you can join us today. I think we've got over 1,000 people registered across our sessions. I know a number of you attend our sessions in person, so we're sorry we can't see you in person today. We do hope you enjoy the event. And welcome to those of you who are new to our event. Those of you who don't know me, I'm Charlotte Sloan. I'm a senior associate and I head up the Gatwick employment team. I'm joined by my colleague Matthew Irwin, an associate in the team, and together we're going to be presenting on the topics today. So thanks again for taking the time out of your day to join us. I'm sure you're all very busy. Life in HR is pretty non-stop at the moment, particularly if you're dealing with some form of reopening of the workplace. We're going to try and help you today to navigate those issues you may be dealing with in reopening in some form. I would say that there's a question and answer box which you should be able to access on your screens where you can post questions throughout the session. So do post your questions there and we will do our best to answer them as we go through, and there will be a further opportunity at the end of the session. If you leave your name and your contact details, if we can't get back to you and answer the question today, we will personally phone you after the session to answer your questions. So do make sure you leave your details there. Got quite a lot to get through, so if we just go through to the next slide. So I thought I'd just start off by sort of summarising what's happened with the lockdown. I'm sure you're all aware of this. But obviously we're now looking at this sort of phased reopening process, which many of you are now having to prepare for. So we obviously had national lockdown imposed as of the 23rd of March. Many businesses by law were forced to close the doors. It doesn't mean that businesses have not continued to operate during the period of lockdown. Obviously, there has been a requirement and encouragement of businesses to continue to do what they can during lockdown, but clearly for some businesses that has not been possible and they've had to close down to a large extent and rely upon the furlough scheme. Now, things changed from the 13th of May and the UK was actively encouraged to return to work a bit more for those who could not work from home, and some workplaces were allowed to reopen. From 1st of June, we had a big change for some. Schools, colleges to some extent were allowed to further reopen. We've got some further changes coming up from the 15th of June in that regard. There are still some businesses, some sectors where reopening isn't happening just yet, but we are now looking at that phased return. So things like hairdressers eventually will be allowed to reopen as well. So you need to be thinking about what you need to do to prepare for that reopening, and there's quite a lot to take on board. We go to the next slide. Probably a word that you've all heard quite a lot at the moment is COVID secure. This is the government's new buzzword. Wait for the slide to catch up there. This is what businesses are required to be before they reopen. So what does that really mean? Well, it means that you as an employer have a duty to take reasonable steps to ensure the safe work environment for your staff. You need to identify the risks, you need to take steps and reduce those to the lowest practical level. And there's various sets of guidance and legislation you can look at to ensure you comply with your obligations there. Importantly, you need to look at the guidance produced by the Health and Safety Executive. That sets out lots of information about what you need to do in identifying work activities, situations which may transmit the virus, thinking about who could be at risk, acting to remove that activity or situation where that isn't possible, control the risk to some level. So do look at that. There's also lots of sector-specific guidance that the government have produced, so you need to look at that as applicable to your organisation and business. There's a lot of similarity between the guidance, and the basic themes from the guidance is that you need to maintain social distancing where possible, but if that's not possible, you need to put in place suitable measures to minimise and control the risk of transmission. Probably a really good example of businesses that have done that already are supermarkets, and they've of course been open throughout the lockdown, and they've had to adapt and had quite a long time to be able to put in place measures. But you can look at those kind of businesses and see what they've done. So screens to protect staff, limits on numbers of people allowed in the supermarket, social distancing when you're queuing up to enter, one-way systems perhaps, all those kind of things, maybe things that you need to be implementing in your workplace, whether that's an office environment, whether that's a retail environment. There are things you can take from that which might be helpful. I think I've heard quite a lot in the past week or so that businesses are doing is videos of what the workplace is going to look like going forward, and sharing those videos with their staff members. I think that can be really helpful. It's something actually my daughter's nursery are doing as well. They're sharing videos of how parents and children need to enter the nursery, need a lined up fashion and what you need to do. I think that can really help your employees as well. It can show them what the workplace is going to look like. It's going to be different. It's not going to be the same. I think sharing that information may alleviate some concerns. I think from my perspective, we're not returning to work at the moment in an office environment. As you can appreciate, solicitors can work from home quite easily. So we are not returning quickly at the moment. But I think when we do reopen, there definitely will be some changes. We may have screens, we may be working at quite some distance from each other as opposed to being quite close proximity. There will be hand wash facilities, etc. All those things will be in place, and I think that's going to be something for employees to adapt to. So if you can share those kind of videos as to what it looks like, I think that will really help them. So that's just an idea, some food for thought there. So moving on to other sort of guidance legislation you need to follow. There's broadly two sets of regulations which you need to be really aware of when you're looking at the return to the workplace and the risk assessments you need to carry out. So if you go on to the next slide, please. The two main sets of legislation you need to look at are the Health and Safety Consultation with Employees Regulations 1996 and the Safety Representatives and Safety Committees Regulations 1977. So those regulations are essentially designed to help you develop, maintain, promote and ensure that health and safety at work is there, and check how effective you are in doing that. If you recognise a union in your workplace, you need to be consulting with your union health and safety representative about your proposals to make the workplace COVID secure. If you don't recognise a union, you need to be consulting with your staff directly or perhaps elected representatives to make sure you are thinking about that and doing that. You have to consult under both sets of regulations, and there are consequences if you don't do that. So it is really important to get this right. Obviously helps ensure you're complying with your legal obligations, but it broader than that, I think it really will help in getting people back to the workplace. A lot of businesses perhaps are sending questionnaires to their staff members at the moment to kind of understand their concerns and deal with those through the consultation process under these regulations. That's something you can think about doing, asking staff to provide you with details about their concerns. And sharing that information. Move on to the next slide, please. And I'm sorry, there's a slight delay on the slides this morning, so do bear with us. So the consultation process that you need to carry out under these legislations, these acts that I've mentioned, is to consult in good time before reopening. There's no set time frame for when you have to consult. The general purpose is to provide informed information to your staff members, consider the issues that they're raising and try to reach some form of agreement and to reassure staff about the safe return to the workplace. That is the aim of the consultation that you're carrying out. You need to be speaking to people who are really concerned about their return, trying to resolve those issues for them. But ultimately, as the employer, you can make the final decision. You've got to take those comments on board, but you can ultimately be in control and make that decision, subject to some considerations about possible claims from a health and safety perspective, which we'll come on to shortly. The other thing I was just going to say to you, if you recognise a union as well, just be aware, if they don't think it's safe for their members to return, they can potentially ballot and take strike action if sufficient numbers vote in favour. And we are seeing, particularly in the education sector, obviously trade unions writing long letters which employers need to deal with, just to minimise the risks of that. Generally, we're finding that communication is key. You're keeping the unions informed, updated, you're generally trying to listen to them. That will hopefully help get them on board and make things a bit easier for you and avoid those kind of situations. Just be aware of that. I'm going to move over to the next slide now. We'll just move that on the screen for you. I don't think we've got any questions come through yet, but do continue to ask questions. If you have got any questions on anything I've said so far, please do post them and I'll do my best to answer them as we go through. So something that we wouldn't ordinarily think about when we're carrying about risk assessments is how people get to and from the workplace. But probably in light of the COVID situation, it's something we now really do need to take into account as an employer. We've all seen, particularly in London, the pretty packed pictures of buses, of the underground. Obviously, that has got a risk for employees when they are transmitting the virus when they're travelling to and from work. So we need to identify what we can do about that. There's some guidance from the Health and Safety Executive about that, which talks about identifying where people can travel alone in their own transport and maintain social distancing, and consider all other forms of transport before using public transport with your staff. We think we probably need to go a bit further than that. We need to be giving employees clear guidance as to what is expected and potentially making changes to how the workplace operates. You probably don't want employees who have to rely upon public transport using that transport during particularly busy times. So think about whether you can stagger start times, end times, which will require a change to terms and conditions, which we're going to come on to in a little bit. Think about whether you can make it clear to employees that actually if that bus, if that train is far too busy, don't get on it, wait for the next bus. That is acceptable. Will you understand that? Will you support that? Encourage them to use hand sanitizer when they're using public transport. Encourage them to not eat and drink on public transport, etc. So we think there's quite a duty there to kind of do perhaps more than you'd ordinarily do when thinking about risk assessments and people's travel to and from work. So just be aware of that. There can be consequences, I think, if people become affected or transmit the virus using public transport when they're kind of leaned upon by their employer to attend work and do it by whatever means that they can, even if that's public transport. So just do really be careful about how you go about that, and again, get legal advice if you're unsure, just to minimise those risks. A lot of this is uncharted territory. We haven't been here before. You probably don't want to be a test case in these scenarios, so I think early legal advice is probably sensible, just to minimise those risks and help ensure that you're not in a situation where you're facing allegations of potential claims from employees who feel that they've been put at risk. Another thing I'm just going to mention on risk assessments, and we'll move on to the next slide now, is about thinking about particularly vulnerable groups of employees and what you need to do in respect of them. So you may need to be taking different, more onerous steps potentially in respect of those employees. And I'm talking here about a few particular groups. So vulnerable people, that being those who are required to shield because they are potentially extremely clinically vulnerable, and those who are clinically vulnerable who may not be required to shield as such, but there are still certain precautions you probably need to take in respect to them because they are more vulnerable. It also applies to people who are living with somebody who is shielding or is vulnerable, so you need to be thinking about that as well. So finding out about your employees' individual circumstances is really important, which is where those questionnaires and that consultation process is really important. Pregnant women are another category where you need to be thinking about in a slightly different way. There are additional rights of pregnant women where the working environment isn't safe for them and you cannot find other work for them, so just be aware of that too. BAM members of staff is another category where there has been scientific evidence, bizarrely, that this affects that group of people more than others. So you may need to be taking additional steps in respect of those groups who are not typically in a vulnerable category at all, but they've got a particular reason why they may be more vulnerable in the context of COVID. Just remember that the government advice is if you can work from home, you should be working from home. So I think you still need to be thinking about that. But it's just if you do need people back in the workplace because they cannot work from home, taking those steps to ensure that the work environment is safe for them as individuals as well as generally is really important and legally required. Going to move on to the next slide now. I think we have a couple of questions. I'm just going to quickly look through those. I think I've answered some of those questions as we've gone through. Yeah, I'll pick up some of those questions further as we go through, and Mackie's going to pick up on some of those points as well. Moving on to the next slide, we're looking at now what the future of the business, the organisation looks like. So you carried out your risk assessment. There's still going to be a number of things that are potentially going to change for the business, unless you're fortunate enough to be in a position where you're going to pick up quite easily where you left off. For most businesses, organisations, you're feeling the pain somewhat of payroll costs, and you're thinking about what you need to do to safeguard the future of the organisation or business. So things you may need to be thinking about, again, we'll go to the next slide, which details those points. You may be thinking already about how you're using the furlough scheme and the extent that you continue to use that. You may be thinking about what changes you need to implement in respect of terms and conditions of employment. Unfortunately, a lot of businesses will need to be thinking about redundancy. We're already seeing a theme of that in the advice that we're giving. And you may need to be thinking about other options like unpaid leave and sabbatical. So we're going to touch upon all those things. Firstly, we're going to go on to furlough. I think the slides are slightly behind, so we're going to skip forward 2 slides to furlough, but just bear with us while they catch up with us. The furlough scheme runs from the 1st of March to the 31st of October. Now, there's been some changes brought about in the recent week or so, which have changed that scheme. And they've changed the scheme earlier than was expected. We're just 1 slide behind, so we're going to catch up very shortly to the next slide. The current rules continue to apply at the moment as they are until the 30th of June. Now that is 1 month earlier than we expected the changes to be in place. For between the 1st of July until the 31st of October, there's going to be some more flexibility introduced into the furlough scheme. And essentially what the government is saying is that workers will be able to return to work on some kind of part-time basis whilst continuing to make use of the furlough scheme to some extent. Now, as is a bit of a running theme with the government announcements throughout the period of lockdown and the coronavirus pandemic, they've made this announcement without a lot of the detail, and there's a number of questions we have about how this is going to work in practice. So I can't answer all those questions that I'm sure you've got in that respect now about how is that going to work, because we simply don't know. However, what I would encourage you to do is complete our feedback form, which is going to be available about 15 minutes towards the end of this session. Tick to say that you would like to receive our updates. We produce email briefings all the time in response to the announcements the government make. So that will get you the latest developments to your inbox directly as and when we get them. So just do that if you're interested, and we'll keep you up to date of any news we get in that respect and how to deal with it. But now, an important consideration to be aware of is that the scheme is closing to anyone who's not already been registered to use it as of the 30th of June. And you have to had made use of the scheme for 3 continuous weeks prior to the 30th of June. So in reality, that means that you have to have registered and been using the scheme by the 10th of June. So that deadline is obviously coming up fast and very fast. So do make sure if you do intend to make use of the furlough scheme that you do get people on that quite quickly. Otherwise you'll be prohibited from doing so. Another change which we're going to come on to on the next slide is the contribution employers are going to be required to make to the furlough scheme. That is changing, and there's going to be an initially modest contribution that employers need to make. So the dates to be aware of, it's all on the slide here, but from the 1st of August, the government will continue to pay 80% subject to the cap, but employers will have to meet the cost of employers' national insurance and pensions contributions. From the 1st of September, it will be 70%, and employers will have to contribute 10%. And from the 1st of October, the government will pay 60%, but they expect employers to pay 20%. So that may impact how you use the scheme, whether you continue to use it, whether you can afford to use it. So think about that, and no doubt you need to do some prior planning to work out whether the furlough scheme continues to be the best course of action for you. It may be that it isn't. It may be that actually some jobs are not savable, and that's where you need to be thinking of redundancy. And that's something Matthew's going to come on to in a little bit. So we touched upon some of the health and safety considerations that you need to be thinking, the risk assessments you need to be doing to get people back to the workplace. An important consideration, which is a bit part and parcel of that, is giving notice to employees about returning to the workplace. And that's going to apply whether people are on furlough or not, whether they're working from home successfully or not. You do need to be giving them reasonable notice of the return to the workplace. This is on the next slide, if we can move across to that, and that will hopefully catch us up shortly. So much as you wrote to employees when you were furloughing them and perhaps telling them that they needed to go home, work from home, take all their work stuff with them, now that you are looking to reopen the workplace in some kind of phased fashion, you need to be looking at giving employees notice of that, writing to them, telling them that their furlough's ending, telling them that they're coming back, and telling them the shape of what it looks like coming back. If there's any change to their terms, that needs to be communicated to them. It is sensible, as we've said, communication is really important about the health and safety risks. So communication to staff individually in that way about the steps you've taken as a business, as an organisation, to make the workplace safe will hopefully help you in getting people back, also help ensure that you're meeting your legal obligations. So do think about that. You may have some people who have difficulties coming back because they're in a vulnerable group. There's those red flag issues you need to be aware of. You may have others who have got childcare issues. Obviously, we know the schools aren't open for all currently, so that needs to be factored in to allow employees to be able to manage that and work around a solution as to how you can get them back to the workplace if possible, or continue to allow them to work from home if it isn't possible. We've helped lots of clients with letters to help facilitate their return to work, so do get in touch if you need any help in that regard. We'd be delighted to help. If we move across to the next slide, something you need to be thinking about is the refusers. We've had a number of queries already about people who are making noises about I can't possibly return and what's going to happen with me, X, Y, Z. Obviously, you need to listen to those concerns. You need to hear what their reasons are for not wanting to return. Is it because there's a red flag? Are they a vulnerable person? Are they in a vulnerable group? Do they have a disability? Are they pregnant? Do they have childcare responsibilities? So do listen to those concerns and address them best you can. So I think, again, communication is key in this, talking to them about how you can avoid these issues. And if you can't minimise risk for them, it may be you're looking at other solutions for them, which may be things like changing their role, continuing to allow them to work from home, and other options. But you need to also be aware and alive to those people who are just saying they don't want to return because they're scared, not necessarily because they've got a particularly strong reason because they're in a vulnerable group, etc. Those reasons potentially are still valid reasons, and there can be potential liability on an employer if you don't address those concerns, which I'm going to come on to next. If you push and require them to come back. We move across to the next slide. And thank you for the questions that have come through. Hopefully I've answered a number of those as we've gone through already. I will continue to answer the ones that have come through as we go along, as will Matthew. Do keep asking them. If you don't get an answer, leave your contact details and we will make sure we get back to you on those. Move across to the next slide, which I think we're now on. So something which we didn't deal with an awful lot prior to the coronavirus pandemic was unfair dismissal protection in respect of those who raised health and safety concerns. I think it's fair to say that this came up occasionally. Quite often it wasn't litigated. There's not an awful lot of case law on health and safety dismissals, so it's a bit of an unknown area as to how tribunals would approach it. But this is something we massively expect to be on the up as a result of this pandemic. So just to outline what the right is. So it's under the Employment Rights Act 1996, there's a right for employees not to suffer detriment or dismissal where in circumstances of danger, the employee reasonably considers there to be a serious and imminent threat to the employee, which results in them leaving the place of work, refusing to return to the workplace, and taking appropriate steps to protect themselves and others. So that is the right in the Employment Rights Act. It's an automatic unfair dismissal claim where an employee is dismissed as a result of this, or where they resign in circumstances where they claim constructive unfair dismissal as a result of the employer's action. You don't have to have any minimum amount of service to bring that claim. So it's potentially quite a broad claim that employees can bring. We think it also potentially extends to workers. The right derives from European law, and the definition of the employees, the type of workers and employees who can bring this claim, we think is broader and wider than just employees. Compensation is uncapped, so as well as being quite a broad claim, it's also potentially quite an expensive claim. So this is something to really take into account when you're trying to deal with people's concerns about health and safety, and that's all part of your risk assessment process. We move on to the next slide, just to explain more about what that right is and what employees need to show. Now, there must be an actual danger to the employees, so there needs to be some form of objectiveness in that claim that they're bringing. The problem is with the COVID pandemic is there probably is some degree of actual danger. There is, we know it's a deadly disease. For some, they're very vulnerable to it. So whilst the pandemic persists, there is that risk of actual danger. The second part of the test is there needs to be a serious and imminence of that danger, which is based on the employee's reasonable belief. I'm sorry about the slides, just playing catch up here. You'll hopefully see them on the screen shortly. So that second element involves that level of subjectivity, which again makes it easier for employees to demonstrate that. It doesn't matter that you don't agree with what their concerns are about the imminence and the seriousness of that danger. It's their reasonable belief. So the more you can do to deal with their concerns, try to show that you're taking steps, the better position you are going to be to hopefully demonstrate that wasn't a reasonable belief. But it is quite a broad, it's quite broad there, so just be really aware of that. Again, I can't overemphasize how important it is to get early advice on it, because you probably just don't want to be a test case in this scenario. There hasn't been an awful lot of guidance. and case law in respect of health and safety dismissals. They typically haven't focused on infectious disease. It hasn't been a big issue in the cases so far, but this is obviously going to change going forward. So to help you minimise those risks, all the things you're doing in respect of health and safety risk assessments are massively important, but it's then the action you take based on those risk assessments, whether you could be justified in that, really needs to be carefully thought about, just to make sure you're not part of any future case law developments on the health and safety aspects. Hopefully that that answers some of the questions that are coming through in respect of health and safety. I'm going to move on next to change in terms and conditions, and I'm going to introduce Matthew, who's going to be talking you through that. So thank you, Matthew. I'll pass over to you.
Thank you, Charlotte. Yes, so as Charlotte mentioned, the furlough scheme is being sort of phased out from August, although it will continue for 2 or 3 more months. But what you may be starting to think is, if you want to bring back your employees, do you actually want to reduce their hours or perhaps their pay? And if so, how do you go about doing that? And I think the starting point is always the contract of employment. You'd expect an employment lawyer to say that, but just check whether you've got a contractual clause that gives you the right to make those changes. And the clause really does have to be very clear, because any ambiguity is used against the person trying to rely on it. So if, as an employer, you're seeking to rely on that clause, it does need to be very clear. A general flexibility type clause, for example, may well not be sufficient to make those changes. I would recommend taking advice, even if you think you've got a good clause, because effectively you are still changing someone's hours or reducing their pay. And there may be an issue with the implied term of mutual trust and confidence. And of course, that can give rise to a constructive unfair dismissal claim. Worse still, if you happen to sort of affect a particular group more than others, then that could give rise to an indirect discrimination claim. So just bear that in mind. We move on to the next slide, please. But what happens if you don't have anything in the contract that gives you the right to make changes? And very often there actually isn't such a clause. In that situation, you're basically trying to reach agreement with your staff, and if there's a recognised union, with that union. Consultation should be a two-way process. It makes sense to explain the reasoning behind your wanting to make the change. Listen to employees with their concerns, their ideas for alternatives, and try and sort of engage to understand and allay those concerns. Ultimately, though, if you can agree those changes, that's great, because then you can just move forward. I would confirm it in writing, even if you're only making temporary changes, just so that it's all clear. Now, of course, an employee may not be all that keen to reduce their hours or particularly reduce their pay. And that's where you do need to give some reasoning as to why they should agree to that. Effectively, the other options may well be a little bit more sort of severe, in terms of potentially you might be looking at redundancies. Potentially, it could be a dismissal for some other substantial reason, where you are going to have to dismiss and then re-engage on the new terms. Now, people ask, given that we've got the job retention scheme, is it possible to make redundancies during that period? And the answer is that yes, that you can, and I'll come on to look at that. But it's certainly something that you need to consider as an option that someone might put forward as to why you shouldn't be making redundancies at this stage. It may be that you are looking to, as I say, dismiss and re-engage under a new contract with reduced terms, but that should really be as a last resort. You would definitely want to try and consult with the employees to try and to get them to agree the terms before you actually go down the dismissal route. And of course, remember that you will need to follow a fair procedure, give the employee notice and the right to appeal. And those changes that you do make will only then take effect once you've rehired the employee on a new contract. Now, it is a delicate balance, these situations, because the tone of your communication is going to be important. As I've said, explaining the reasons that you need to make the change is probably going to be helpful. And there is an element of persuasion to this. I would probably avoid the kind of Godfather making them an offer they can't refuse approach, but you get the point. There does need to be some persuasion. Certainly don't use anything threatening in your language there, because that's not going to be helpful. But I think staff in this unprecedented situation are going to accept that perhaps it is better to stay in a job where you may have a slightly lower pay, but at least that is better than potentially being made redundant in what will be a difficult jobs market at the moment. Moving on to the next slide, please. A survey from the Institute of Directors, the lobby group, has found that of 1 million companies that they surveyed, a quarter of those said that they expected or that were at least considering making redundancies as we come out of furlough. So obviously that doesn't sound great. And I thought I'd quickly touch on collective redundancies, or sorry, collective consultation. Now, this arises where an employer proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. And what's confusing here is, in this context, as redundant applies to any reason for a dismissal that isn't connected to the individual. So it's not kind of their conduct, for example. So it would apply to a redundancy dismissal, but it also applies to these re-engagement, dismissal and re-engagement type dismissals. So just bear that in mind, because that is also something where you can be caught in collective consultation. And the penalties for not following collective consultation can be quite severe. You can end up with a protective award of 90 days gross pay per affected employee. So that can add up. And there's also, as you'll know, a requirement to inform the Secretary of State for Business that you are going to make that number of redundancies. And there's a potential criminal penalty if you don't do that. So it's definitely worth considering these things, and actually probably taking some advice if you think collective consultation is going to apply. I'm moving on to the next slide, please, to look at some problem areas that might arise with collective consultation in the current climate. Before you can consult with collective consultation, you do actually need to have employee reps. Now, you may have them in place already, but if you don't, you may have to consult with a union. If you recognise a union, then you have to consult with the union. Otherwise, you will need to have employee reps in place. Now, it may be that you have to do that by an election, but what you can do probably in the first place is to ask for volunteers. And if you decide how many reps you're going to need, and then ask for those volunteers, and if you get about the right number or slightly fewer, then you don't need to carry out an election. And in fact, even if you have maybe 1 or 2 extra, you may decide, well, actually, we can proceed with that number of representatives. and therefore not go down the election route. So what's the sort of situation when you've got staff that are furloughed? Well, the answer is you can still carry out collective consultation even if you've got your staff furloughed. There may be some practical considerations though, such as allowing, how do you allow the representatives to get access to those employees? Excuse me. Yeah, and you'll probably have to meet some extra costs in terms of the cost of communicating with those employees. I've put in there that there is a special circumstance defence that sometimes people try and rely on, and that is where you just say you can't carry out collective consultation because it's sort of so sudden and so disastrous that you just have to crack on with that. And that defence has usually only been used successfully when there has been that sort of sudden shutdown of a business or an unexpected disaster. Now, you could say that this pandemic is pretty unprecedented and use that, but I think the furlough scheme has given employers a little bit of breathing space. So actually, it seems unlikely that you will be able to use the special circumstances defence for not collectively consulting. You're probably not going to be able to say, oh, it was the time of Corona, it was unprecedented, nothing we can do. So just bear that in mind. It is going to be worth collectively consulting if that applies. Moving on, please. Told us, the government in relation to the furlough scheme has said that whilst on employees who are union or non-union representatives may undertake duties and activities for the purpose of either individual or collective representation of employees or other workers. But that's clear that those reps can work in terms of collective consultation. What the guidance also makes clear is that employees aren't able to do anything which makes money or which provides services for your organisation whilst they're on furlough. But I think given that consultation in relation to potential redundancies doesn't really make money or provide services, then it would seem reasonable to conclude that you are able to consult with furloughed employees about those potential redundancies. That question has come up. Moving on, please. It's going to be interesting to see how furlough impacts on employees' arguments in relation to redundancy or whether there's an unfair dismissal. Remember, if you're consulting on a genuine redundancy situation, you would still need to take into account what your employees say about potential other options or counter proposals. So it's likely that perhaps the job retention scheme is put forward to say, well, look, you shouldn't be making redundancies when we've got the furlough scheme. At very least, it'll probably be recommended as a sort of short-term solution rather than necessarily long-term. But the fact that the scheme is in place does not mean that you can't make redundancies while it's in place. You still can. While it is, though, you would certainly need to show that you've given some consideration to that the fact that the scheme's in place before you decided that you thought it was definitely right to go ahead and make the redundancies. You would need to show that you'd factored that in. Again, I think I would recommend taking advice, especially if you're considering making quite a few employees or roles redundant, or certainly if your business is unionised. Next slide, please. The rules in relation to notice pay and redundancy pay, even if you're in the furlough scheme, The normal rules will apply, in certainly that you would have to, sorry, we've skipped a slide. Can we go back one? The normal rules will apply in that employees still need to be given notice before they're made redundant or paid in lieu of notice. And of course, they should still receive a statutory redundancy payment if they have got the 2 years service or more for you. It's possible that you can serve notice during furlough. That's the case. One question that arises as to whether or not you actually can base the notice pay on their furlough pay, or whether you would go back to normal pay. And unfortunately, the answer is that it slightly depends on the nature and the type of the contract. So you will need to take advice on that. What it is clear is that I think you can use the furlough grant towards those notice payments. So that's helpful to a certain extent. Going on to the next slide in relation to redundancy. Redundancy pay, the calculation, the question arises as to whether you should base that calculation on their furlough pay or on their normal pay. And I think the answer is that it is safer to use the pre-furlough pay, the normal pay, for the calculation. And remember that what is clear is that the guidance makes it clear you cannot use the furlough grant to meet those redundancy payments. So that's definitely the case. Just move on to the last slide, please. So I appreciate that we've tried to cover quite a bit, but as Charlotte started off saying, when you start to think about coming back, certainly you want to think about conducting a COVID secure health and safety risk assessment. Do think about whether you've got any vulnerable people that you know, how it'll affect them returning to work. Give no notice to return to work. Don't just sort of say, right, you've got to rock up tomorrow. That's not sensible. And as we come to sort of the furlough scheme drawing to a close, I think it is sensible to start thinking about how that's going to affect the business. Do you need to start making any changes, either in terms of numbers or perhaps in reduction of hours or pay, and plan ahead for that. And then, of course, finally, just think about the numbers, and if the numbers are potentially in that level of having to collectively consult, certainly take some advice on that. And I would also factor in the time that you're going to need to do that. It does take a little bit longer, and moving forward, see whether or not you can get some good advice on how to deal with that, and individual consultation at the same time. I think that's it from me. Thank you for listening. I think we do have a bit of time now for some questions. I'm going to hand back to Charlotte to sort of wrap up. Oh, we can't hear you, Charlotte.
Thank you. Can you hear me now? Thanks, everybody. Thanks, Matthew. So thanks very much for all those questions you've been posting as we've been presenting. Hopefully we've answered some of those questions as we've gone along, but we're going to answer the ones that we haven't best we can next. I just wanted to flag that the feedback survey is now live, so if you could kindly complete that, would be really helpful. That will help shape our future events. It's useful to have your feedback. We really value that. There's also opportunity for you to subscribe to our mailing list to make sure that you do receive those updates that we've been talking about. So do complete those for us as best you can. Put your contact details and we can get back to you on any questions we've been unable to answer during this session. So moving on to questions, I think we had a few questions in respect to my section about whether the obligations in respect of health and safety are legally binding or whether it's just guidance. So hopefully I addressed that during the presentation, but just to make it clear, there are legal consequences if you do not comply with health and safety law. So there is legal consequences as a result. So you do need to be taking these steps. The key things to be aware of is the health and safety legislation that I mentioned quite early on at the presentation. There's a common law duty of care to take reasonable care for the health and safety of your employees. And then there's breach if the employee suffers harm which is caused or materially caused by the employer's acts or omissions, and the harm was reasonably foreseeable, and it's reasonable and just to impose liability on the employer. So that's where the actions you've taken to ensure that the environment is COVID secure are massively important. All employers owe a duty of trust and confidence to their employees, and if you breach that, that can result in constructive unfair dismissal claims. And I mentioned the health and safety unfair dismissal claims in particular, because there's no minimum requirement for a level of service. So even your employees with less than 2 years service, and potentially also your workers, may be able to bring some kind of claim in respect of detriment they suffer or dismissal, or a resignation, which is deemed to be in circumstances which is constructive unfair dismissal, where you haven't done enough to secure their health and safety at work, or they consider that you haven't done enough, or perhaps you've done a risk assessment but the actual implementation of that risk assessment hasn't happened in practice. So it's not just the theory of completing these forms, publishing them on the website, etc. It is about taking continual and active steps to ensure the health and safety of your employees, which is going to change as this situation changes. So it's not an easy task. So I really don't envy you having to do this, but we can absolutely help you to make sure that you do your best to minimise the legal consequences. So do get in touch if we can help you further on that. There was a question, Matthew, about case law in respect of where you have to dismiss and re-engage, and asking what is the case law reference for allowing you to do that. So do you want to just answer that question if you can come back on live, if that's okay?
Help! I don't think I don't think I know the case off the top of my head, but there's definitely law that says that you can do that, but obviously it is a question of making sure you follow a reasonable process. And I think that the key when you're dismissing and re-engaging is that you do have to have a sound business reason for doing that. It can't just be that you sort of think, well, this will be helpful. It does need to be a sound business reason. So yeah, hopefully that's helpful.
Thanks, Matthew. I think I agree. There's lots of different case law in respect of dismissal in those circumstances, but the key thing to be aware of is the Employment Rights Act. You can fairly dismiss potentially for some other substantial reason, and that is the potentially fair reason that you're relying upon. But as Matthew says, it's very much about ensuring that you have got good justifications for that change you're trying to implement, and then dismiss the employee and re-engage them on. So again, get some legal advice on it if in doubt. It is not that straightforward. It is probably best avoided if you can, because it is a dismissal at law, which can result in claims. So trying to get employees' agreement to it, trying to get them on side is often the best way. And a lot of that comes down to communication and how you relay the message. If you are making changes to avoid more onerous consequences like redundancies, you hopefully stand a better chance of getting employees on side. Probably in this climate, it's not a situation where you can easily say to employees, we're taking this away, but we're giving you this instead, because then maybe there's nothing else to give. It's just simply a means to save the business, and that's what a lot of employers are doing at the moment, and successfully securing the employees' agreement to changes which otherwise they may not have been willing to agree to. It's difficult circumstances, and employees, I think, if it's communicated in the right way, do understand that. Hopefully that answers that question. There were some more questions about the furlough scheme and the closure of that to new entrants. I just wanted to clarify that. Employers will only be able to furlough employees that they have furloughed for full 3 weeks prior to the 30th of June. So the final date for which an employer can furlough for the first time an employee will be the 10th of June. So just be aware of that date. And again, if in doubt, get some advice around it to make sure you are using the scheme as appropriate and as you need to.
I've got a question. There's a question here from John that he's asking that could there be issues if for staff doing the same work, redundancies are targeted solely at those employees who have been furloughed rather than those that are not? That's a good question. I think you would need to be careful. I wouldn't target redundancies at those who've been furloughed. I think you would need to consider across the board, as you would do in a normal redundancy situation, and not focus on those who have been furloughed, just to avoid a risk of, well, I wonder what the type of claim would be, but I think it would have to be more on the basis of unfair selection, potentially some discrimination claim if they could think of a way of bringing that.
We've got another question here as well, agreement in writings, where you are agreeing changes to with the staff, whether you need to confirm that in writing if consultation is done over telephone, via Zoom, and that sort of thing. So absolutely, agreement in writing is key. We absolutely recommend that you get that. Maybe that you can do that by email rather than a formal letter, but generally a formal letter is the best way, that they can sign electronically to confirm their agreement. So yes, absolutely think about written confirmation. I'm conscious of time because we are close to wrap up. So I just wanted to say a massive thank you to Hayes, who are virtually in the room with us today. So we're delighted to have partnered with them, and do obviously, of course, direct your recruitment questions to them. They'll be sure they'll be fine to help you with those. And a big thank you to everyone who's been able to attend today's session. Hopefully we've done our best to answer the questions you raised throughout. I'm conscious there's a few that we haven't been able to get to, but we will of course pick up with you after the session. So again, leave your contact details, telephone number, email address if you prefer, and we will get back to you as soon as we can to answer those. Your feedback is really appreciated. So if you do have a few minutes just to complete our feedback form, that would be greatly appreciated. We will use that. We'll take on board all the comments for our future events. And I say it kind of gives you the option to sign up to our email bulletins to get those latest developments. So please do that and get in touch if we can help you with anything at all. We'd be delighted to assist. So thank you so much, everybody. I'm sorry we can't be with you in person.
Thank you.